Well, all you Facebook users out there, get your computer mouse ready. Chances are that you are going to like this story. The Fourth U.S. Circuit Court of Appeals ruled unanimously on Wednesday that the like button is just like sticking a political sign in your front yard and therefore is protected by the First Amendment as substantive free speech. The ruling comes from a 2009 case involving a Virginia sheriff who ran for re-election only to have a number of his employees like the Facebook of his opponents. When he won, he dismissed a number of them from duty. And that is how this whole like button Facebook debacle came about. So will this pave the way for retweets or YouTube likes or anything else to be constituted as free speech? Well, let's get to today's tech report. Matt Binder is the producer of the Majority Report, and he joins me now to weigh in. Thank you so much for being here. Can you go into a little bit more detail about this case?
Sure, Megan. Basically, the Fourth Circuit Court overruled lower court's decision that Facebook likes did not constitute protection under the First Amendment. Simply because I guess they felt clicking the like button is just inconsequential or just not significant enough to fall under protections of free speech. But the Fourth Circuit Court ruled that it is indeed an expression, and like you said, we've previously said that putting up a campaign sign. Also, there's been, political armband statements, burning a flag even. These are all things protected under the First Amendment, and I see no reason why the Facebook like shouldn't be protected under the First Amendment too.
So who exactly does this ruling affect? Could people from a private company like negative posts about their bosses without a fear of repercussion?
I mean, with a private company, it's always, I mean, there's protections, but there's always, I mean, there is still, I guess you can say, freedom of speech, but not freedom from the consequences. In this particular case, though, it was a deputy sheriff, so it was a public service. So, I mean, is this something you're going to fire someone over? I mean, it seemed like something petty between the sheriff and the deputy sheriff. And on top of that, the like is so, it's so vague, the Facebook like, especially when you're liking a page, or even on Twitter when you're following someone. I mean, I follow Donald Trump on Twitter. I'm not a fan of Donald Trump. I basically follow him to make sure I can see what he says so I can heckle him and hit him every now and then for his political views. I mean, he has over 2 million followers. 2 million people do not like Donald Trump, please.
Nice.
It's basically, you have to look at it as it is. Does the First Amendment protect all forms of these speeches? It doesn't, or does it make does it make a difference between how significant the speech is? And it doesn't. The First Amendment does not say, it has to be sincere. There must be sincerity behind it. There must be some sort of significance. If it's political speech, you're protected by it.
I'm glad that you brought up Twitter, although I'm not sure our founding fathers would have had any idea what that was. But do you think this paves the way for retweets, even if you're a company or the government doesn't agree with what you're retweeting? Or how about YouTube likes?
I mean, I definitely think that all these forms of social media interactions should definitely be covered by the First Amendment because they're forms of expression. I mean, we're living in an era of Citizens United where money is speech. I mean, people who use the internet, they can get the internet anywhere. They can go to the library. You don't need to have money to use the internet. So this is a form of speech that maybe the affluent or the politically connected have access to that others do, too, that others don't.
So combating millions and billions of dollars of money with millions of likes, right?
I mean, if you can spread the word through activism on the internet, and that transforms into on-the-street activism or political activism that changes laws, creates laws, I don't see a problem with that whatsoever.
But at the same time, does this blur the line between what is and what is not exactly speech?
I don't think so. I mean, speech has been, like I said, it's been covered under many forms of expressions. Simply because he didn't, in this case, the deputy sheriff didn't say that he liked this candidate outright. He didn't say the words. He didn't type those words out. I mean, if he was saying that over the phone, if he was writing it down and sending a snail mail, these are all things that he would have the freedom to do so. But simply because it's online, I think the problem is that our laws, or in this case, how people are interpreting these laws, haven't quite caught up with the times, the internet age. I mean, when you do something online, you don't enter some Willy Wonka chocolate factory, a land of imagination where things don't really exist. I mean, things online, what people say online, this is what they believe, this is what they say, this is how they feel. These are all legitimate interactions. These are all legitimate forms of speech.
And Matt, finally, the most important question that I have to ask you, why is there no dislike button on Facebook?
I wish there was. It would make life a lot easier if you can dislike someone and still follow them. And maybe this deputy sheriff, maybe that's what he was doing. Maybe he was trying to help his boss out and follow his political opponent to get some dirt on him. I don't know. But yeah, if they were less specific with the terms used when you want to follow someone, so their statuses or tweets or videos show up in your feed, maybe it would save people a lot of trouble.
Thank you so much for weighing in. Matt Binder, producer for The Majority Report.
Thanks for having me, Megan. I really appreciate it.